Hi everyone, and thank you for joining us for today's panel discussion to talk about the EU Schrems II court ruling. My name is Annie and I will be the facilitator for today's session. So today's presentation will be given by a set of panelists who are all lawyers in the jus laboris firms in the UK, Germany, France, and the Netherlands. But without further ado, I will then hand over to our moderator, Alexander Milner-Smith from the UK. Go ahead, Alex, you're welcome to start.
Thanks very much, Annie. Welcome everyone to today's session. I will start by saying there have over the last few months obviously been a number of sessions on Schrems, and indeed I think everyone on this panel have spoken at many different ones. And indeed, I think I'm doing 2 or 3 in the next 3 weeks. So we appreciate some of you will have heard a number of the points we're going to make before, but we thought we would do one for jus laboris and try to think about some of the more relevant issues for workplace. So some of our scenarios are going to be workplace based, which is something that I haven't seen before. Regarding the format of the session, we really want you to take away some practical ideas and also be able to cover any burning questions. What I will say, I think the title of this session is, what do we know now? Do we know any more? The answer is probably no. We possibly know less than we did on July the 16th. So we're not going to be able to answer every question, but we will try. There simply are no answers to some of the questions. So we have a mix of speakers who are going to cover off general points, run through some scenarios, and also talk about their specific country. So you should get from this an understanding of the judgment, a holistic understanding of the view in the UK, France, Holland, and Germany. And then crucially, we hope some practical takeaways, practical in inverted commas, because the judgment is not a friend of practicality, shall we say, and nor is some of the guidance from regulators. Specifically, Jessica, I'm looking at German regulators, and Jessica is going to discuss some of their interesting comments shortly. But we're very lucky today to have speaking me, perhaps not so lucky about that, but we're very lucky to have Jessica from Germany, Elisa from Holland, and Basile from France. I'm first going to set the scene now about what Schrems is, the underlying law in Chapter 5 of GDPR, just so everyone broadly knows what we're talking about. So just in terms of the next slide, Annie, I just want to start with Chapter 5 of the GDPR, which is really, why do we care about Schrems and transfers outside the European Economic Area? And broadly we care because Chapter 5 says, in very summary terms, that data should not be, personal data, should not be transferred outside the European Economic Area unless a number of provisions are met. First, as set out in Article 45, you can send data to a country that has been adjudged as adequate by the European Commission. So that includes most recently Japan, Canada, for those companies that are under the Canadian Data Protection Act, New Zealand, Israel, Switzerland, and so on. And I will say there, as a future and horizon scanning point, one hopes in the future that the United Kingdom as well will of course be adjudged as adequate. And the EU-US Privacy Shield, which is at the heart of Schrems, was also a sort of adequacy decision. It was a partial decision of adequacy by the European Commission in relation to the United States, as long as the receiver of data in the United States signed up to the Privacy Shield terms. So I think many people miss that. They think it's a sort of another Article 46 way of transferring data, which I'll come to in a second. But that's not correct. It is a form of adequacy. It's not total adequacy like Japan, but it's partial adequacy. And if I was a US receiver and I sign up to Privacy Shield terms, I could have, up to July the 16th at 10 AM, received data from the European Economic Area. Other options that people use and that are very common are covered by Article 46. So binding corporate rules, where one particular entity or group around the world would have signed up to binding rules around its data processing, so that allows me to see, a company in Singapore has binding corporate rules, therefore I can send my data to them. Even more common though are standard contractual clauses, which are clauses approved by the European Commission, approved quite a long time ago now actually, in 2001, 2004 and 2010, so over 10 years old and predating the GDPR. But these broadly, again, validate transfers. So if I wanted to send some data to the United States or to Singapore, I would put in place the standard contractual rules. There are then other theoretical things like ad hoc clauses and codes of conduct, which I won't talk about now. There is then also Article 49, which is entitled Derogations for Specific Situations. And this is where there isn't a decision of adequacy, you can't use binding corporate rules, there are no standard contractual clauses, but you might use one of these derogations. Basil's going to talk more about them later, but things like explicit consent. The data subject says, yes, I consent to my data being sent to Brazil or elsewhere. And for instance, contractual necessity. The example always given is, I want to book a hotel in Peru. It's therefore contractually necessary for me to send some data to the hotel in Peru and so on. So then what did Schrems change and what was Schrems about? Which is the next slide, Annie. So in short, the case was initiated by Max Schrems in 2015. He was a data activist who had previously succeeded in getting rid of Safe Harbour, which was the precursor to Privacy Shield. He got that invalidated in 2015, and some of you will recall the scramble to come up with another transfer mechanism to transfer data to the US. And what happened was Privacy Shield emerged. But after his successful Safe Harbour challenge, Max Schrems then turned his attention to Facebook's use of model clauses, the standard contractual clauses. And he broadly says, and the arguments are more complex than this, but he broadly said, doesn't really matter what the paper says, doesn't matter that everyone signs up to standard contractual clauses. When the data is received in the United States, the NSA, the FBI, the CIA can demand that Facebook hand over that data, and therefore a European data subject's rights are not protected, no matter what the paper says in terms of the standard contractual clauses. Now, at the same time, the Irish Data Protection Commission raised concerns about the use of model clauses in general, and there were some concerns also raised about Privacy Shield, and a reference was made to the Court of Justice of the European Union. In, I think, January 2020, the Advocate General of the Court of Justice of the European Union set out a strange opinion, but quite a welcome opinion, setting out that standard contractual clauses were a valid transfer mechanism, but perhaps exporters would have to do a little bit more just to check that the paper did work. And he didn't really draw any conclusions on Privacy Shield, although he did express doubts about whether it was potentially a valid mechanism. But we were all quite happy with that opinion because we hoped the Court of Justice of the European Union would follow that approach, perhaps making some suggestions regarding standard contractual clauses and some suggestions regarding Privacy Shield, but ultimately leaving the final decision on next steps to the European Commission and the US Federal Trade Commission to decide how to update Privacy Shield or how to update standard contractual clauses. Unfortunately, we all got a bit of a shock on July 16 when the Court of Justice took a slightly different opinion. Rather than follow the quite gentle and moderate approach of the Attorney General, the AG of the Court of Justice, they came up with their Schrems II judgment, the notorious Schrems II judgment, which broadly and in summary says, Privacy Shield is no longer a valid mechanism for transfer of personal data between the EU and the US. However, standard contractual clauses remain a valid mechanism on paper, but anyone who is using them has to make sure that they do actually work. So the paper is not undermined by intrusive surveillance techniques in a particular country, in this case, all looking at Facebook in the United States. So how did they come to this view? And look, it's a long and complex judgment, and they had more submissions than I think they'd ever had in any case before, although admittedly everyone was only limited to 20 minutes, so I'm not quite sure how detailed your submissions could be in 20 minutes. But the judgment is long and complex, but broadly they found, and this is the crux, the requirements of US national security, public interest and law enforcement have primacy, thus condoning the interference with fundamental rights of persons whose data are transferred into that third country. So in other words, because the CIA or FBI or NSA have broad powers to demand that US companies hand over data and to review data sets held in the US, this is at odds with the concept of Privacy Shield and the continuing protection of EU data subjects' data when it arrives in a third country. Therefore, Privacy Shield, boom, gone. And as a final point, they also said there was no means of redress for a data subject as well via the Privacy Shield. So the bottom line is that from 16th of July, Privacy Shield is no longer a lawful way to transfer personal data to the EU from the US. And this is obviously bad news for the 5,300 US companies that had signed up to Privacy Shield, and the many hundreds of thousands of European companies that, of course, relied either intra-group or with their service providers on those Privacy Shield certifications. So it was rather a bad morning, I think Thursday, the 16th of July, for all of us. And just in relation to SCCs, Standard Contractual Clauses, the court very helpfully said they remain a valid mechanism, so they don't discount the Standard Contractual Clauses as approved by the European Commission. However, they suggested that in order to rely on them, controllers and processors must undertake onerous due diligence to show that the actual receiving country or the importing country, however you wish to frame it, can guarantee the same protections for EU data subjects. And further, they also emphasise that supervisory authorities have the authority to audit and review the use of standard contractual clauses. And ultimately, if they feel the paper exercise is just a paper exercise and is not, does not actually help protect EU data subjects' data in the country of receipt, can actually stop that transfer. Now, this all sounds wonderful, but the Court of Justice didn't suggest how one undertakes this due diligence. So very helpfully, the next day, the EDPB, the European Data Protection Board, came out with its own FAQs, which is the next slide. And we're all hoping for a wonderful, gentle, look, don't worry about this, you've got a 6-month grace period, we're going to release guidance over the next year, everyone just relax. But no, they didn't say that. They said, 1, no grace period. So theoretically, everyone from the 17th of July should be checking all their transfers to make sure they're valid. And not just to the US, they said that the European Court's assessment of US law should be taken into account for not just transfers to the US, but all countries around the world. And also not just in relation to standard contractual clauses, but also in relation to all the other mechanisms for potentially transferring data that I discussed under Chapter 5. They also very helpfully said that Article 49 derogations were only ad hoc. So that is then their future scanning to stop people saying, well, okay, I can't use SCCs, I can't use Privacy Shield, but everyone's consented for the data to go to Brazil or the US. They also said, okay, we recognize the Court of Justice has said maybe we need to do due diligence and maybe supplementary measures can be put in place to be additive to the standard contractual clauses or binding corporate rules, but they did not suggest that there was any practical solutions, or they did not make any suggestions in terms of what those supplementary measures might be. They did, however, very helpfully on the 4th of September, spend hours coming to a conclusion, which was, we are going to create a task force to look at this. So almost 2 months later, the only thing that they have done to help is create a task force, which is going to look at what on earth we're all supposed to do. That is very similar to how I used to do my revision when I was doing my exams, in that I would always write revision timetables and I'd never do anything. So I think you can tell from my tone what my view of this judgment is. I think it's a highly impractical and very difficult judgment that causes a lot of problems. But I just think before we go on to some of the real life scenarios and how we approach them, I'd just like to go around the other panelists and get 1 minute on what the feeling was on the 16th, 17th of July and what the approach in your country has been since then. So I think, Jessica, I will come to you first just for a 1 minute colour commentary on how you felt and how Germany's approaching it. And don't forget to unmute yourself, Jessica.
Okay, sorry. Thank you, Alex. Very similar to what you were saying. This judgment is not very helpful for practicalities and companies. The German data protection authorities of 2 states, and just as a reminder, we have federalism, so we have state data protection authorities. 2 of those authorities have issued statements. One of them is very difficult to overcome. It's very triumphant about European data protection. The other one is more practical and actually giving some guidance. I will go into the details later.
Thanks very much. And Elisa, what about in the Netherlands?
Well, in the Netherlands, there is very much a wait and see attitude after Schrems II. So businesses are mostly now focusing on COVID-19 and also the privacy issues related to that. And actually, Schrems II has not been very much of a hot topic for clients yet. And furthermore, most companies are already relying on SCCs and think that they can still simply rely on their SCCs, which of course happened after the safe harbor was declared unlawful. And therefore, companies are really waiting for further guidance from the EDPP and for further, well, new versions of their model clauses.
Okay, thank you. Yes, and I must say, you know, one of my comments that I've written about in various articles is it's a strange decision to make at the height of a pandemic. It's the kind of the least thing that people really want now. But Basil, what about France?
A bit the same than in the Netherlands. Actually, this situation has raised many complexity and difficulties for French companies. Unfortunately, today the French DPA hasn't placed these topics on the hot topics. So we are highly waiting for the guidance from the Europe in order to see things clearer now in France.
Thanks very much. And I will say what the ICO, I mean, supervisory authorities' hands are slightly bound here. They cannot, like I can do, criticise the judgment in such fruity terms. They have to behave a little bit more respectfully. I mean, in the ICO, the ICO in the UK have said we'll continue to apply a risk-based and proportionate approach, which broadly means, one hopes, with a nudge and a wink, we recognise this is difficult, so we're going to try your best and we will be gentle with you. There has just been an interesting question, which I will just deal with for 15 seconds. A very clever, actually, an intellectual question, which I could speak out for hours, but I'll just do it in 15 seconds. Does this mean we've moved from ensuring the adequacy of data privacy laws in the country of the data importer to actual equivalence with the GDPR? The answer has to be yes. The Court of Justice of the European Union has misunderstood what standard contractual clauses are. If we're all supposed to be adequate all over the place, then there should only be transfers allowed with adequacy decisions. Standard contractual clauses are designed to give protection to allow sort of equivalence as opposed to to allow a form of transfer, understanding that there are different laws in different countries. So it's a form of data imperialism, which the Court of Justice of the European Union is frankly doing in many other spheres, competition law and so on. But yes, that is the route that they have taken. There are various groups within the European Parliament who want that as well. But that is the direction of travel, and that is an almost impossible, as we say in the UK, circle or square to circle or circle to square, because there are things that we cannot do as a company. Imagine how long it takes the European Commission to do an adequacy decision. It takes them months and months and years, and yet we're being asked as a controller, a corporate controller, to make an adequacy decision based on Singapore or India or Vietnamese security laws. It's a ridiculous situation, but I won't hold back, so forgive me there. But hopefully we can get on some more practical stuff now, Annie. We're going to ask Jessica on the next slide just to have a look at the first scenario, which is about intra-group transfers in a workplace context. Thanks, Jessica.
Thank you, Alex. Yeah, we do have a lot of clients who actually are puzzling how can they now transfer their data within the group, their HR data and possibly also other data. And as I stated, there has been practical guidance from two of the German data protection authorities. One is more or less putting a halt to all non-EU data transfers. It is very, very restrictive. The other is much more practical and actually giving some guidance on amendments. So I'll go over what we would suggest now to our clients to do. First thing is look at the circumstances of the data transfer. What is the other country, the recipient? So here it is the US and Singapore. Both not exactly countries that have been considered to be adequate. And in case of Singapore, you could also doubt if it's a full democracy. The categories of data, are there special category data? Are there possibly data that may be of interest to any secret services? This goes into the evaluation. Are there any suitable grounds for the transfer? Why is it required to collect those data outside of the EU? Are there any alternatives collecting HR data group-wide within the EU? So those are the circumstances. Then the next thing is to consider the outcome. Is there an alternative? Could this be redesigned in a way to concentrate data in the EU? If not, the data controller and exporter needs to take legal, technical, and organizational measures to ensure they are doing their best to come to an adequacy level. And that includes restricting data, encrypting them, and anonymizing them, also amending the standard contractual clauses. And here the guidance of one of the authorities in Germany comes into play. They have explicitly recommended a whole set of various clauses to add to standard contractual clauses that allow additional safeguards against access from secret services, and also give data subjects more rights. So this is the second step. The third step, very important, is documentation of everything. There should be a data protection impact assessment, a written analysis of what are the risks, what are we doing against them. Every single measure should be documented, and this should be an ongoing, careful and ongoing process. And then maybe the fourth aspect is, what are the risks if in case of any international data transfers to non-EU countries? Transfers may be suspended by data protection authorities. They have explicitly announced to do so. There may be fines, as we have all been speaking about for the last 2 years, those typical GDPR fines. And one of the German authorities, the Berlin one, has explicitly pointed to damages as well. Damages for non-material torts. And so the immaterial damage is to be compensated in an amount that can be threatening. So those are the risks, and this is what we advise our clients to do in such a situation.
Thanks very much, Jessica. That's very interesting. And I think someone has asked whether you can share the additional clauses that the Baden-Württemberg, which I pronounced wrong, forgive me, Jessica, but authority has set out, and I'm sure we can do that. Just in answer to the second question on that, does amending the SCCs not invalidate them? Absolutely. That is why that advice is rather strange from that authority. I am assuming, and I must say, I read that as potentially side letters or additional clauses, as opposed to things that you would insert into the standard contractual clauses. So what we're recommending is, if you feel after a transfer risk assessment that the answers you've received are not adequate, let's take a US example. If you feel that if someone has not been able to give you assurances that Section 702 of FISA doesn't apply to them, or that they, in the past few years, have had approaches from the NSA or similar. By the way, the Snowden revelations make clear that those kind of requests are actually very rare, but some companies might not be able to give you that assurance. So if you feel you have to move into the supplementary measures and supplementary contractual clauses, we would suggest it's sort of an addendum to the SCCs or an addendum to the DPA under which the SCCs are incorporated. Notwithstanding that German guidance, which is very interesting and very useful, I just think there might be some other regulators, for instance, Basil the CNIL perhaps might say, what are you doing amending the SCCs? So I think you can get to the same outcome with amending your DPA and adding in extra clauses there, rather than actually touching the purity, shall we say, of the SCCs, because we're not technically supposed to do them. That's very useful, Jessica, and I think we're going to move on to Elisa, who is going to have a look at it from the perspective of not so much intra-group transfers, but all the multivarious and nefarious maybe, service providers that we use in the HR world. How do we approach them? And also give a little bit of colour on Holland.
Yes, well, the difference with the scenario that Jessica just talked about is, of course, that then you have external parties to deal with, for which you are not always first on their list. For instance, Amazon and Facebook are not going to sit on the table with you to negotiate about the content of standard contractual clauses. So it's questionable what your negotiation position is. It depends on, of course, the external parties that you have to deal with. So EU organizations should now take stock of the transfer mechanisms they are using, and roughly you can place them in 3 buckets. The first one is, of course, organizations using Privacy Shield, so for data transferring to the US. For that bucket, you need to take immediate action after Schrems II, because it's not legal anymore. And so you need to move away from the shield and turn to other solutions, such as, for instance, standard contractual clauses. And also you should adjust your privacy notices and policies that refer to Privacy Shield. So that is your first bucket of transfers. And then, well, the third is, of course, transfers on a very low volume. For instance, the example on the slide, a Brazilian expenses company with occasionally transferring. We do not have time for that. So be pragmatic. If there's nothing in place, put in place at least the standard contractual clauses that are now available. And of course, situations where the transferring is now based on an adequacy decision, such as Japan in this example. The effect of such an adequacy decision is that the personal data can flow from the EU to the third country without any further safeguard being necessary. So in other words, transfers to the country in question, Japan, will be assimilated to intra-EU transmissions of data. So no further action is required here for now. And then the second bucket, where you have the most action, of course, needed, is where you have data transferring with more substance based on standard contractual clauses. But for instance, your bucket 1 will go into bucket 2 also. If you move away from Privacy Shield, then you go for standard contractual clauses. For instance, the example of the HRIS cloud services provider that now moves to from Privacy Shield to standard contractual clauses. After Schrems II, you need to take additional assessments and include additional safeguards. So the law around standard contractual clauses is not new. However, before Schrems II, it was only kind of a paper exercise, and it has now become a significant and legally complex assessment of how the clauses are actually complied with in practice. So you should carry out a thorough assessment of the data processing and, crucially, the local law that applies to the data importer, including specifically the law governing access by local authority to data. So it's a very challenging exercise. You could start with asking the importer how they expect to be able to meet the obligations from the model clauses. So to go back to the question, Alex, the advice is to take various measures. One very important is proper accountability. It's a key pillar of the GDPR. So put in place an international data transfer policy to explain what you do, how you do it, and why you do it. And second, the advice is to carry out this surveillance law assessment or data export impact assessment, or how you call it. The third one is to look at technical measures, so data minimization, encryption of data. Sometimes it's possible to move to a server in a country that has an adequate level of protection. However, that is rarely the case. And the fourth point is to agree on additional contract terms to the standard contractual clauses, like Jessica just described. And you could take a look at the examples of the local authority that Jessica referred to in Germany. And my final advice would be, before we get back to you, Alex, do not panic, however, start preparing.
Yeah, and I agree with that. And I think one of the key points there there's a slight nuance between what Jessica said and Elisa said, in that when you're doing it from an intra-group perspective, you're very much in control of everything. It might be complex, but you can get your subsidiary in Singapore, even your parent company in New York, to sign up to things. You're all on the same page. You're all pushing in the same direction. They will answer your questions. Everyone understands what is happening here and what you're trying to achieve. The difficulty, though, is with service providers. You have some that Elisa mentioned that are so large, unless you're a very large company, you're unlikely to be number one on their list, and they won't negotiate with you. Now, we're hoping that they are going to do some of the work for us in that they should be providing FAQs to you saying, hey, have you heard about Schrems? Don't worry about it, it's not really a problem at all. That's the kind of thing I want to receive from a service provider, and explaining to me as a controller what I am doing. And indeed, for some of our service provider clients, and if we can go on to the next slide, it's not so relevant for, so we've obviously covered all of this kind of stuff. Maybe it's the next slide, Annie, forgive me. So we don't cover this so much today. Obviously, all of us on the call advise clients who themselves are processors, who are service providers. We are advising them to positively reach out to their clients, proactively work out their own position. How does Section 702, how might it affect me? Oh my goodness, I'm heavily based in Russia. I better produce a paper for my clients so that they don't all want to withdraw their business from me. There was a message that came out from Microsoft, and I'm not praising any specific company. It was just it just happened to come out a couple of days after Schrems, which was really a PR exercise. They were talking about how they always object to requests for data. They were saying, we're with you, we are data champions, because they were trying to assure literally the millions of companies that use 365, that use Microsoft Teams and so on, that we are on this. But they also need to be realistic that with their million consumer clients, they're not going to be able to get around everyone. They're not going to be able to update their terms and conditions. So it's a don't panic game, but you just need to be aware and prepared for what is happening. And I think just one more slide before we go on to Basil, Annie. So these are the kind of supplementary measures. This is our guess. Jessica's referenced some of them. Elisa's mentioned some of them. So, you know, we might be putting some contractual mechanisms. I like to put in a double warranty, pointing out to the importer that there are already warranties in the standard contractual clauses that say that they do work. By the way, you've got to be very careful, because even as the exporter, there are warranties you give. So that's a double-edged sword, but I like that double warranty. I always like to put in promises to implement further measures to ensure they work, because goodness knows, on Christmas Day probably, the European Data Protection Board, sort of just when Santa's coming down the chimney, will release some new guidance, which means we will have to do 8 different things. So I want that built in contractually, that they have to do that for us. I want, by the way, this is already in the Standard Contractual Clauses, controller to processor, but I want an even more explicit notification requirement that if they are approached by a government, you better tell us within 6 minutes, because we want to know this. Then an absolute promise that they will challenge governmental approaches, and you can see how impossible this is. I probably won't go on. You can read the slide for yourself. It's some of this. How is a small company supposed to negotiate this with its cloud provider? The inequality in bargaining power is so different. It's going back to your question, Robert, about have we moved from adequacy to equivalence, or the other way around, whichever we want to frame it. Yes, the European Court of Justice is essentially in some ways asking every single exporter to become a mini European Commission. And I have had to look at legislation that I've never wanted to look at before in my life. I don't want to look at the security laws of South Africa. I don't care about that. But I'm having to do it and try and help clients, and they're having to spend money to learn. Anyway, obviously make sure your liability clauses, if you can, are beefed up so you are not liable. Both Jessica and Elisa talked about security, you know, increase encryption at rest and at transit, try and avoid the NSA tapping up that cable in Frankfurt to grab all the data of all the European citizens and so on. Slightly outside all our specialisms, I talk a good game on security, but I'm not a security expert. And then due diligence. Elisa's point around having, we call it a transfer risk assessment, but having an extra EEA transfer policy. If you have that, that's your roadmap about what you do. It's your accountability document. So if you are ever in trouble, you can at least hold that piece of paper up and say to a regulator, I did think about this. I wasn't just guessing, but it takes a while. I've written to X cloud provider. They haven't got back to me. And you're just trying to build yourself a defensive narrative. However, there are potentially other options that we might use, and I'm going to move over to Basil and the next slide, just to run through whether there are any clever things we can do and a little bit of horizon scanning. Thanks, Basil.
Thanks, Alex. So, as indicated by Alex, there is some options that could, and I really insist on the could be eventually used by companies, because Article 49 of the GDPR provides some derogations for specific situations where the transfer of personal data outside of the EU may be carried out even if there is no decision of adequacy, or even if no appropriate safeguard has been put in place. However, and this is the reason why I really wanted to insist on the could as an option, because these derogations can only be used on very limited situation. And for example, we have some statement from the European Data Protection Board stating 2 years ago expressly that such derogations, and for example, the derogations are the following. You have the possibility to transfer personal data where the data subject has given his explicit consent, but also where this is necessary for the performance of the contract. And first, the European Data Protection Board said expressly that these situations, these derogations, can only be used on a very occasional basis and not for repetitive transfers. And in France, we have also this statement which has been taken expressly by the CNIL, the French DPA, stating that unfortunately these derogations will not help for transfer outside Europe on a usual basis. And then, because there are a list of derogations, and as indicated in the slides, the main ones are the control, so the consent of the data subject and the contractual necessity. But concerning the explicit consent, this derogation has in itself its limits, because as you know, we are talking about HR data, the transfer of HR data, and here the consent given by an employee, actually in France and in many countries in Europe, can be challenged because the employee is linked by its employer by a subordination relationship. So this is important to keep in mind. So it can be challenged. And then thanks to the GDPR, the consent of any data subject may be withdrawn at any times. So there are very important limits that are provided with these derogations, and explaining why we could not rely on these for usual data transfer. So then we can go on the next slide, perhaps.
And Basil, I might make one point there. You'll have to forgive me. And you're absolutely correct. And it's not just guesswork. We have the CNIL view on this. We also have a very long guideline paper from the EDPB, where they really hammer home what is referenced in the recitals 111 to 113, where they talk about the transfer is really very occasional and necessary. It's just a very difficult thing. The only reason I might consider derogations is as some kind of fallback position, where you might say in a paper somewhere, if the SCCs are rendered invalid, then actually we think in the alternative, but without prejudice to that argument, these derogations work, because it would at least give you an argument. But we are seeing occasionally on the consumer side, just I suppose apropos of nothing, but it is interesting. I have discussed with some clients, should we be emailing 15 million consumers, explaining to them that we transfer data to a country where the Court of Justice of the European Union has said it's dangerous for their data, and then ask them for their consent? I have said, do not do that, because that is a terrible PR move as well. So it's just another example of where we're in just a terrible sort of dead-end street where there are no answers really. But something, it might just be a little safety net you could put in a paper somewhere, in my opinion. Sorry, Basil, for interrupting.
Oh, thank you very much, Alex. So given the situation and all we explained concerning these issues, we are now all looking for the very near future to get more security and to be, let's say, a bit safer in our situation. And concerning the next future, we could talk about first new standard contractual clauses, which are very likely to be taken because it was on the beginning of September 2020. We have so let me spell it, the Committee on Civil Liberties, Justice, Home Affairs of the European Parliament, who indicated that new standard contractual clauses are likely to be issued. But concerning first the timings, we have no specific, we have not a specific idea of when this will be done. Some are saying that it will be by the end of this year, but it seems a bit short, so we will see. And the question about these new standard contractual clauses will be around their validity, Will there be modernized? Certainly. Will there be GDPR compliant? Certainly too. But will there be valid, compliant with the Schrems requirements? We will have to see this. So this is the first thing we will have to keep in mind for our near future and the horizon. And then we have also, because we are talking about the privacy shield, which has been challenged, and we could in the next month also have a new privacy shield, so a Privacy Shield Mark II. So again here, how likely, no specific idea. And concerning the timing, for example, last time the Safe Harbor, the ancestor of the Privacy Shield, was challenged. It took around 8 months before the Privacy Shield was issued and entered into what was effective. So we will have to keep in mind that before having a new Privacy Shield, it is really likely that several months just will pass. And also keeping in mind that all of this is happening during the US election, which will certainly not help which will not help us to have a new Privacy Shield. So this is the main thing to keep in mind for the next future. And in any case, we all it will be very important for us to have these new set of rules at the European level to secure our transfer, because following the decisions, the Schrems decision this summer, we already have new litigation, or we already have new complaints or legal actions. For example, as indicated in our slides, we, for example, have the Data Protection Commissioner who issued, I think, Alexander, it was in September 2020, who ordered to Facebook to stop the transfer of data to the US. So there is this, for example, this action, but we also have a claim which has been issued by an NGO, a non-governmental association. This action, yes, this is a fine which has been issued by this NGO, and the name is None of Your Business. I was looking for the acronym. And this association has issued action in 30 European members countries against 21 European companies to challenge the validity of their transfer of the transfer of their data to the US. So here again, this is a big case. So many actions, many litigation, and this is the reason why it will be very helpful for us to have, let's say, quite quickly, new set of rules to ensure the security, the validity of our transfer to the US.
Yeah, very good. Thank you, Basil. And just to clarify a couple of things there, a little bit more colour. The Irish Data Protection Commission and the Commissioner herself has issued only a preliminary warning, a notice to Facebook. And Facebook, one hopes, and I fingers crossed to it, please, hopefully that will take years and years and years and years, because otherwise that will be a difficult thing for use of standard contractual clauses to the US, depending on what that notice says. So one hopes there'll be many appeals and even another reference to the CGEU. But NYOB is actually Schrems' own operation. And they've sued 101 companies. They've chosen them at random. Basile said 30 countries. But the most bizarre group of companies, some very big corporate entities, but also the Catholic University of Luxembourg. Not quite sure what they did particularly wrong, but it's a completely random selection. And it's just because he is getting fed up of the European Commission and the Court of Justice dragging their heels, as we might say in the UK. I mean, the Court of Justice has obviously done him a favour now, but he is going to challenge everything. So Privacy Shield 2 will come out, he will challenge it. But let's hope it goes on and on and on. And maybe I will have retired by the time the next challenge happens. And as a final point there, these new standard contractual clauses will come out. But it then raises a question that we're all scrabbling to put in place standard contractual clauses with Privacy Shield, ex-users of Privacy Shield, as Elisa said. And yet we're going to put them in place. And then maybe in 3 months' time, there's new standard contractual clauses. So that is why it is important, as I said, to build in the right for you as the controller, that if there needs to be another clause put in, it is going to be put in. And I think we'll just end on Brexit. And by the way, I will break some data rules here by just wishing also Elisa happy birthday. Well done. It's a private message, but well done. Happy birthday.
Thanks.
Fun to be doing this. So Brexit. This does cause some issues. It causes a general issue potentially with adequacy. That is already up in the air. It shouldn't be up in the air because from a pure black and white law perspective, the United Kingdom is adequate. We apply the GDPR, for goodness sake. The UN Special Rapporteur on surveillance practices said only last year that our surveillance programme was something that other countries should look at. It would also be it is just a little bit rich for the European Court of Justice to actually be a judging on people's surveillance rules, which, don't forget, is something that is wholly accepted from the treaties of the European Union. So no one is allowed to comment on Germany or France or Holland's security position. It's accepted. So anyway, but that's more of a political point. But this can only be negative because it will give credence to some of the people in the European Parliament who just want to bash the United Kingdom around. And what an easy way to say, nope, from the 1st of January, everyone has to put in place standard contractual clauses or binding corporate rules. Now, let's say we have to do that. It's not a problem. Let's put in standard contractual clauses. But do we now have to also do, if I'm an exporter from the European Union, do I have to now do an adequacy, well, inverted commas, a transfer risk assessment of the United Kingdom? I would suggest, by the way, that would be quite easy to do. And if you do want someone to do that, we can do that very easily. But it's just another thing that you do not want to do. And by the way, in its infinite wisdom, the UK government, of course, has just adjudged the European Union and all its countries and Switzerland and the other EEA countries as adequate. We don't want to play that game. But there is a very strange point there as well, that Schrems II is technically now part of UK law and it will be post-Brexit, all right? So we have to also, when we're just from the UK exporting to the US or Brazil, also have to think about this. But even more weirdly, I think it's in 4 years' time the government is supposed to look at this general position of adequacy in Europe. We theoretically are supposed to look at some countries within Europe, and I'm not criticising any country or making any comment, but Poland or Hungary have interesting surveillance laws. Are we in the UK going to have a Max Schrems who is going to suddenly say, we're not allowed to transfer data? So it will be interesting. And I just wanted to end for 1 minute each for all three of these fabulous panelists. I sound a bit like a game show host there, but that is what it is. I just want 1 minute on what you think is going to happen with Brexit, or if you have one additional colour thing you want to cover that we haven't covered off, do let us know. So Jessica, just one last minute. And you're muted again. Forgive me, Jessica. Sorry.
The UK has been a model student over the last decade or so in the guidance your ICO has been issuing. And I've been following that the UK has been demanding an adequacy decision. And it will be interesting to see what happens by December or by January 1st. There may, of course, be reasons of, I don't know, either political side or COVID-19 for delaying that decision, but I don't understand it from the data protection side, at least.
Yeah, I agree. I think we might see something like data for fish. Two totally contradictory positions, but that could happen. And maybe Basile, and we'll end with the birthday girl.
Thank you. So a bit the same for France. We will be waiting for the adequation decision. The CNIL said that for the current time, hopefully we can still transfer data, but after the Brexit will come into force, it will be the possibility to continue to transfer data to the UK will depend on the adequacy decision. So we have this position from the CNIL, but actually this position is only stating that we are waiting for this adequacy decision. So we hope to have it as soon as possible.
Yeah, I mean, so one of the themes of today's seminar, I'm afraid, has been we're all waiting for some guidance. So forgive us for that. We cannot make up the guidance. Although I must say, just before we finish with Elisa, let's get that German guidance. The Baden-Württemberg one is very useful. The Berlin one not so. But Jessica, if you could share that, I think that'd be very, very useful. And then, Elisa, one last comment from you, and then I think, Annie, we are done. Unless anyone has any questions.
I see that it's already shared in the chat, the Baden-Württemberg guidance. So people can click on that, and maybe we can email it after the webinar. Nothing more to add actually from the Netherlands. I would assume from a privacy perspective that it will be, well, that the UK will be seen as an adequate, well, that there will be an adequacy decision, but it's a political game. So we will, of course, see how that goes.
Very good. Well, I just leave to me, Annie, just say thank you very much to everyone. Very interesting comments, and I hope everyone enjoyed it. One comment, which we'll cover, Annie, you can cover afterwards, I think, yeah.
Thank you.
That's also it from me. I think we're pretty much done here. I would like to thank everybody for attending, and thanks also to our presenters for their insights today. So with that, this webinar will now be ending. Thank you.